Morning. Welcome to the First District Court of Appeals. We have two cases to be argued this morning. Mr. Thompson, Mr. Donovan, good morning. First case, State versus Garang. And then the next case is State versus Jackson. Dan and Mr. Cummings. Great. Just let me know how much time you want for rebuttal, Mr. Thompson. How much time would you like for rebuttal? 5 minutes, very well. You may
Everybody ready? Okay. May it please the court, counsel. I'm going to focus today on the first assignment of error, which raised the sufficiency and weight of the evidence on the endangering children conviction here. There are three issues raised. Whether Mr. Garang violated his duty of care, whether he created a substantial risk to the health or safety of his son, and whether he acted recklessly here. I think effectively the arguments are the same. We have a situation here where Mr. Garang is at home. He gives his 4-year-old and 9 or 10-year-old, it's not totally clear how old he was, gives him a bath. There's also a 17-year-old boy at home. Each child has a room, and after the bath, Mr. Garang lays down with his youngest son, and it sounds like the middle son, who's in question here, went to his room as well. Somewhere along the line, Mr. Garang is either asleep or just laying down, and NG ends up in the neighbor's backyard.
Counsel, this was a behavior that NG had engaged in before?
It's not clear if the backyard and the pool had happened before, but there was testimony that he had left the house before.
And specifically gone to this neighbor's home?
That is not clear in my recollection. If it's there, I'll take the court's word for it, but I just recall leaving before and that it hadn't happened in the recent past.
Let me ask you this, sir. Is there, this child is 9 or 10, is walking around the neighborhood naked, maybe has some deficits. Is there a greater responsibility on the parent in consideration of the fact that the child may not be thinking as another 9 or 10-year-old child?
Ultimately, I think the questionable mental health or mental state of the child isn't fully developed in the record, but there is case law to support the idea that a child with special needs would require extra care.
Well, but I think that was my follow-up question, which is, like, does the record clarify whether there were any special needs here? I mean, it seems, we can draw inferences, but was there any actual evidence about that?
No. The words are mentioned, but there's no expert, and I don't recall Mr. Garang, who would be the one to know, testifying to that.
And there was some indication that the family did not speak English. Is that correct, or do we know that?
Yes, then there's an interpreter as well. I think the 17-year-old spoke English, but I don't know about the younger boys, and I know that Mr. Garang needed a Nepali interpreter. To be sort of casual about it is ultimately, I just don't understand why this case was prosecuted. This is well beyond, I think, what a child endangering children case is supposed to be about. This isn't a child in the back seat of a car where the parent's driving drunk, or a passed out parent who left their drugs and their loaded gun on the table with the kid at home. I don't know what Mr. Garang was supposed to do here. There's no indication that until the police showed up that he had any idea that his son was out.
Counsel, the state's case seemed to focus on two particular aspects of this fact pattern. Number one being the swimming pool in the neighbor's yard, and number two being Mr. Grung falling asleep. Could you focus on those two facts?
The pool, I think, one, there's no evidence that I can recall that NG had ever tried to get in this pool before. Two, it was a fenced-off pool. It was locked with a padlock. I'm not blaming the neighbor at all, but I am saying that those things were obvious, and there's no trespassing signs. There's beware of dog signs. Even if you don't speak the language, it's clear that this backyard is people are supposed to stay out of it. And I think, although there's no evidence necessarily of what was in Mr. Garang's mind, that it would be reasonable for anyone to assume that that yard was adequately protected. So I think that ultimately the pool is really only there because it happened, not because it was actually a risk that
Well,
anyone should have
And I think,
anticipated.
so what is the substantial risk? I mean, is the substantial risk the pool or is it something else?
I think the court ultimately relied on the pool. Our position here is that it's just not a substantial risk. I think it was no more of a risk than the fact that they were on a road. That, it's a thing that was nearby, but the neighbor took adequate precautions. It's just simply where this case ended up. And the question is really, was Mr. Garang reckless? I'm not even sure he was negligent. I don't know that a parent should face an endangering children charge and a conviction for falling asleep for 45 minutes with a 10-year-old, and his 17-year-old is home as well. There's no indication of yelling or hearing the door open and close or anything like that. He had a gate on the normal the normal entry and exit door. There was some testimony that maybe they used the garage. And the neighbor was actually clear that everyone knows his garage door is open and he's out working. So in line with the sort of cases like Bush and State versus Allen, and it's just, I don't know what else Mr. Garang could have done except stay awake and stay with his son.
And is that a realistic burden to put on parents 24/7 to be awake and monitoring their children all the time?
No, I don't think it is. And I think we know for a fact people have to sleep for 8 hours roughly. And if he worked night shift and this was during the day, or even if it was in the middle of the night, it's an unreasonable burden to say it's reckless to fall asleep for 45 minutes.
And counsel, if I'm remembering correctly, the child entered the neighbor's yard the first time perhaps through the garage or on foot somehow. And then the neighbor brought the child back home. But then the second time, the child brought a chair over and climbed over the fence. Is that something that's foreseeable that the child will do?
I think if it was, the neighbor would have foreseen it. So no, the answer is no. And Mr. Garang doesn't have this interim where he learns that this is happening. There's no knock at the door. There's a strong indication that even if Mr. Garang was asleep, the 17-year-old ought to have heard someone trying to give warning. There was indication there was some tension between these neighbors. So drawing inferences from that, it seems an awful lot like the neighbor brought the child over to the yard and went back about his business. If there are no further questions, I'll reserve the remainder of my time and just ask that the case be reversed on the sufficiency and weight of the evidence.
Great, thank you. Mr. Donovan?
Good morning, Your Honor.
Morning.
Working in reverse order, as you had asked a question about the second time in the chair, there were actually two incidents in which the child had entered and actually got to the edge of the pool. And then there was a third incident where the child had been taken back, at least once. It's a little bit unclear as to when the officer went there, but there certainly was an incident where the child had been put back into his own property, and then had grabbed a chair and was going to climb over the fence in spite of having just been told not. In terms of any evidence of special needs, the closest we have is just his behavior and engagement and things in a statement that he was nonverbal, but there was no specific testimony beyond that.
Right, well, I think kind of what I'm thinking about as I'm reading this case is, when my kids were 10-ish, I certainly fell asleep, I certainly took a nap, and is it possible that they would have exited the house and done something? Sure, it's possible, but there's no way to guard against that completely under all circumstances. So I'm just trying to figure out, what is the burden that we would impose on parents in these situations?
Yes, sir. So I would challenge that in terms of, one, the testimony is unclear. Mr. Grum told the officer that he was asleep at trial. He testified that he wasn't asleep, that he was just laying down. But the court did not believe that. The court said, I believe that you were asleep, specifically in its ruling. Two, this was a known risk. The neighbor had testified that she had repeatedly, on several occasions, warned them about the child in the pool. Yeah, I believe it was specific to that child. I don't believe there's any mention of warning of another child. Two, Mr. Garone testified specifically that, the kid had gotten out on a regular basis. That this was kind of a habit for him, which is why they had the baby gate at the front door. Establishing.
But I thought that he also said that he had not done that in a while. I don't know what that while means.
That's true. And in order to then credit that, you have to believe his version over the state's version.
Counsel, can we focus on the risk of this? So I accept the facts that you're pointing to in the record, that there was some knowledge on the part of Mr. Garone that his child had left the house before. What, though, is the risk of a 9 or 10-year-old leaving the house and going to a neighbor's house, even going to a neighbor's house with a swimming pool? What exactly is that risk? I mean, children wander around neighborhoods all the time. Why is that a strong probability that he's going to be harmed?
There's a swimming pool there. Children drown in swimming pools unattended all the time. And so I think, as the trial court found, that it is an inherent known risk of a swimming pool. Additionally, there have been numerous cases in which a child roaming around by itself naked in a neighborhood by streets. There's no indication as to how busy the street was because the focus was on this backyard, but numerous convictions of far less time than this out and about.
Right. I'm familiar with those cases, and they involve much younger children and much busier streets. And the subtext of those cases is that those children don't know how to navigate the traffic that they're going to encounter. I think we can make some assumptions that an older child in a more residential area would be better equipped to navigate a streetscape. So how do we read into the risk calculation here, given that we're dealing with an older child, a neighbor who appears to be, although angry, attentive to the situation, and a pool that poses certainly some risk, but maybe not a strong one, that the child is going to drown?
I would challenge you on that, Your Honor, that there is a very, very good reason why every single public pool in the country will not allow children into it unless a lifeguard is on duty. And that it is an exceptionally known commodity that pools present an inherent risk to children. In their brief, Mr. Garone points to that there's no testimony that he didn't know how to swim. Well, there's no testimony that he did know how to swim, but what we know is that multiple times he got towards the deep end of that pool, And I don't think that there is a parent in the United States that would be comfortable just letting their 10-year-old play in a pool by themselves unsupervised. But for the neighbor being there, that child would have gotten into that pool. I think that's clear that he was absolutely committed to that concept. And his ability to appreciate the situation, I think, is contradicted by the fact that, one, he's out roaming around in the yard naked at 10 years old in the middle of the day. Two, that he's corrected multiple times not away from the pool, and yet continues to go towards that. And three, that when the officer was there and they were trying to pull him away, he tried to scratch and bite and claw at them as they were trying to take him back to his house, showing his dedication to the idea of getting to and getting into that pool.
Exactly, right? I mean, children are not robots. They have minds of their own. And what is a parent to do? I mean, what level of burden do we put on a parent to control a child of this age?
I would say that Mr. Garung was well aware that the child, and testified that the child could open the garage door, knew that the child could open a regular door, hence the baby gate at the front door. There could have been a baby gate at the back door as well.
Was
to
there any
prevent that.
testimony that there was affirmative testimony that there was not a baby gate at the back door, or that there were not additional security measures at the garage?
The testimony is that the garage door and the door from it into the house was wide open, both by the victim and then Officer Medecki, who called out and said that he yelled out 8 or 10 times as loud as he could as he was trying to get somebody's attention. So the idea that a simple knock on the door would have, one, that somebody else has to intervene and take action to alleviate him, Mr. Garung, of his responsibility. A knock simply would not have been sufficient when nobody responded, when the police officer is bellowing as loud as he can, according to his testimony, 8 or 10 times before, and he's getting to the second floor before somebody finally appears, indicating that, yes, wow, we had a 45-minute window here. Absent the intervention of the witness calling the police and the officers being there, that this child would have been out unsupervised, roaming around for a much longer period of time. So I would say that if you have a known risk, my dogs get out all the time. They used to. I had to take precautions to put additional locks on the fence so that they couldn't open those doors. You have the child door handle locks that make it harder for a child to open a door. Any of those actions could have been taken to secure any points of egress out of the house, but that there's no indication that they were.
But do we know that they weren't?
Ma'am, what we know is that the garage door was wide open and that the door to the house was wide open for at least 45 minutes. And that the court discounted Mr. Garung's testimony and did not find at least one, specifically did not find one portion of it credible. So his self-serving statement that the child hadn't done this in a long time, it was reasonable for the court to have discredited that and not taken that into account. And as the court's well aware, a case isn't, a conviction isn't against the manifest way simply because the trier of fact chose to believe the state's version of events over the defendant's.
So when just to make sure I understand the state's position here, like if Mr. Garung, like tonight, goes to sleep and, he's asleep and anything can happen while he's asleep, like, is he committing child endangerment by going to bed at night? What's he supposed to do?
Take steps to, if he certainly, now on notice as to, now we absolutely know that he's on notice of all those risks. If he were to go to sleep without leaving that door secured in any fashion and the child were to open it and to get out and be wandering.
But then on the flip side, if we bolt people into a house and there's a fire, there are levels of protection that we can take. And I remember my parents putting a fence around our backyard. Well, guess what? We figured out how to climb that fence. And so there are levels of protection that you can take, but short of like locking a kid in a room, which would create its own issues, like at some level, like it has to be reasonable.
Certainly, at some level, yes, sir. But however, in this case, you have a known escape risk. This would be akin to, you said in the amount of a fire. If you have a child that you know has a predilection towards setting fires, and yet you leave them with a box of matches in their room unattended, that's a known risk that that child will start that fire. In this case, once again, we have a known risk that this child gets out on a regular basis. This gentleman had been warned multiple times by the neighbor about this in the past. He was on notice from the neighbor. He was on notice from his own knowledge that the child had gotten out on several occasions. So, yes, we don't know. The record is completely silent. I would expect that had there been a baby gate at the back door, at that door, and that the child had defeated that would have been something that would have been elicited at trial. It was not. We don't know whether or not the garage door actually was closed when Mr. Garone went to sleep, or whether that back door leading from the garage into the house was actually secured. He said that it was, but he also said that the child knows how to open that door. So it's a known risk that we have. And in terms of that kind of thing, there are certainly some children, fortunately, my children didn't have this predilection. I didn't have to take, some of those precautions. Yet I still had the child-proof door handles on all of my doors, and electrical outlet panel covers. And there's a reason why the state law in every single state and every single municipality in every single area of the country has a rule that, a law that pool owners have to have a gate and to prevent access to a pool, because pools are inherently dangerous. He had been warned about this pool before. He was on notice that the child had a tendency to escape, and his actions that day simply were not justified. I'm assuming I'm out of time.
You've got 2 minutes left.
If there are no further questions.
Thank you. Mr. Thompson?
I just wanted to clarify a few things. I don't believe there was any testimony that this took place 3 times that day. It was just 2. I didn't see any testimony that there was a prior warning from the neighbor that the child was trying to get into the pool. And in the court's findings, I didn't see any discounting of Mr. Garong's statements that this hadn't happened recently. So, and I think there's just this question of, does having a neighbor with a pool enhance a person's duties? I don't think so. I can't see a reason why. I think that somebody else having a pool isn't Mr. Garong creating a situation that's risky to his child or violating a duty of care. And for those reasons, I fail to see, frankly, how the duty of care, the substantial risk, or the recklessness was met in this case. So I'd ask that the court reverse.
Great. Thank you. Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day. Or I guess you're staying here, so
He's at the wrong table.
you can stay at that table. We'll figure it out.
Just move the nameplates.
Please, how much time would you like for rebuttal?
5-6 minutes, Your Honors.
Very well.
Thank you. Your Honors, I'm standing here heartened, actually. I feel very good about this case, and I'm not talking about the legality of it, but when I read the record, I realized that this case really represents the community working with law enforcement to help keep our communities safer. if you look at the background of this case, the officers started off their testimony at the hearing by saying, well, you know, we had roll call on this day, and they said there'd been a shooting in this area, and the police department had been flooded with calls from residents and from neighbors and from community members and some juveniles themselves reporting this shooting and also saying, look, there's going to be a retaliation, you know, be on alert because this happened in our community and we feel something else. Yes.
The trial court found that there was no probable cause here, and I don't see you defending or resisting that in your brief. So is the state's entire argument on reasonable suspicion?
That's absolutely, yes. This is all the officers needed was presented to them, the totality of circumstances, the background of the shooting in that area, not just somewhere in Springdale.
The background of the shooting, like, I get that, but
Yeah.
would that just give the police license to search any car in that general vicinity?
Not at all, and that's
Then what's different about this car?
we have another tipster that specifically, I guess, after all these calls came into the department, these officers took their shift, and I guess a few hours into the shift, a tipster called and said, hey, there's a suspicious car and some suspicious occupants in this area, in this location. And so this is not just a general
But what does that
sweep of
mean?
a
Like,
parking lot.
I mean, what does that mean? They don't say, like, these guys have guns, these guys have drugs, these guys were involved in the shooting. They don't say any of that kind of stuff.
Right.
They're just like, it's suspicious. Like, what does that mean?
Well, we don't know. I mean, but somebody felt it was necessary to pick up the phone, and it was important enough to tell the police that these people don't belong here, that they're suspicious, the car's suspicious. In light of the shooting on that street just hours earlier, which the police were all alerted to be on the lookout for, this is going to be a rising tension situation in this area.
Do we even know
Yeah.
that this call or this tip had anything to do with the previous shooting? I mean,
No,
could it have just been
could have been.
because the person making the call felt uncomfortable?
Could have been. It could have been. It just goes to the totality of circumstances. But unlike the trial court's finding, which was that this was, you know, just a general vague shooting somewhere in Springdale, it wasn't. It was on the very street where they were dispatched to. Again, they did not just randomly go to a parking lot and start hassling people in the lot. They were dispatched to this particular lot to look for this specific car. That's what drew them there. And when you combine everything they knew about that area, that tip, what they were supposed to be on the lookout for, that in and of itself gave them reasonable suspicion to briefly detain the occupants and say, hey, look, what are you doing here?
So the briefly detain, you know, the justification for Terry is that these are minimal intrusions. Like, I need to check your ID, I need to make sure you don't have a weapon when I'm encountering you, something like that.
Right.
What I saw in the video was the complete opposite of that. It wasn't like, hey, let me check your ID, make sure that you're, you know, the owner of this car or something. It was officers approaching with guns drawn, ordering the people out of the car to walk backwards, to then get on their knees and get handcuffed.
Right.
So that to me seems to be the fundamental opposite of what a Terry stop would be.
Well, that's going to describing how it went down, but really, if you look at the reasonableness for why it occurred in the first place, was it reasonable for the officers in this situation to stop these people and ask them for their IDs? The officers say, we get these calls that somebody doesn't belong in an apartment complex, and when we get these types of calls, what we do is we approach the people and we say, hey, do you live around here? What's your ID? That's
Why
what their
didn't-
intent was to
Why
do
didn't
here.
that happen? Why did it go from, we're just checking this out, we got a call, to you need to walk backwards, don't turn around and look. We've got a gun on you, and now you need to bend over on your knees so we can handcuff you and put you in the back of our cruiser. Why did it go from that minimal level of just asking a question to a full-blown, forceful arrest?
Well, it was the circumstances unfolded as they did. They didn't intend for it to go down that way. They just wanted to talk to these occupants and say, hey, who are you guys? unfortunately, they started to leave the complex, and I guess it's a narrow area, and they felt, and I agree, that the Constitution allowed them, it was reasonable for them to detain these people and say, hey, look, somebody called and said, you know, you're suspicious, can you show us your ID? I think that's reasonable here. I don't think their approach or their intent to detain these people and ask them a few questions is unreasonable. Now, the way it went down, the force used was for the officer's safety because they weren't exactly
Based on
sure.
what? Based on what?
Well, first of all, if the stop is proper, which is the state's contention it certainly was, the officers certainly would have been derelict had they ignored the tip and just let these people drive away. The community depended on the cops to investigate this. They wanted this investigated. The cops, that's why they're on the payroll, to look into things to keep the community safe. They had every right under the Constitution to say, hey, look, guys, what are you doing back here? Now, when these guys took off, they activated their sirens and their lights, and the car stopped, which is what they're supposed to do, which is good. If at that point, if we all can agree that that was a reasonable stop, then the law allows the officers to ask them to step out of the car, put their hands out, walk towards them. That's MIMS. You can do that. If the stop initially was proper, you can ask them to exit the car. You don't need to even have a suspicion of crime. It's all part of the investigative detention process.
And so your position is that what occurred is asking them to step out of the car, and it falls within MIMS?
Yes, absolutely. If the stop was proper, and to me, that's really what this whole core issue is, was it reasonable for the officers to stop these guys and say, hey, look, what are you guys doing back here? Given everything that went down this afternoon, the shots were fired, somebody's called us and said, you guys don't belong back here. What's going on? Do you have an ID? That is reasonable. I think the citizens didn't call the police to be casual observers. They don't want the police just to show up and look around. They wanted this
I
investigated.
don't want to put words in your mouth, but I do want to make sure I understand. So what I'm hearing is that your position is that MIMS allows the action, and it doesn't dictate a form of the action. So the MIMS order to get out of the car could be simply what I just said, please get out of the car. Or it could be the more forceful order, the more forceful way of taking that action with guns and what, what occurred. Walk
Sure.
backwards, get on your knees, all
Absolutely.
of that. And MIMS, in your position, embraces all of that.
Right, because in essence, you're just asking them to step out of the car. That's the invasion. That's the intrusion. Now, whether or not you're nice about it and charming, or if you're a real jerk and you yell at them, the Constitution doesn't get into those kinds of nuances, I don't think. I think if it's reasonable for officer safety to ask them to step out of the car, I don't think it becomes unreasonable just because they're screaming it or yelling it or they insult them. I mean, that's not the inquiry.
So the presence of the gun, the order to walk backwards, the handcuffs, those don't change the calculus.
Correct. That's the Hairston case that Justice DeWine wrote. If as long as the initial stop is valid, then it's not rendered invalid just because you turn on a light or you yell at them or you show a gun. That's just affecting safely the interaction, and it's not only the officer's safety; it's for the occupants of the car too. And again, it goes back to the reasonableness of that initial stop. And I think it's important that this court send a message to the community and the law enforcement. We want to encourage the community to call police. If you see something, say something. I don't think we should send a message.
This case is a Fourth Amendment case, you agree, right?
Sure.
And the Fourth Amendment isn't about what message the court sends the community.
Right.
It's about protecting a particular criminally accused person's rights.
Sure.
And that's what we're here to talk about. What
Absolutely.
the Fourth Amendment means vis-a-vis a criminal defendant, right?
True. But, there's also the practical side of things. And if an interaction like this is going to be viewed by the community as, well, don't call the police, they can't do anything anyway, it would be very unfortunate, because I think what the record is before this court is a very reasonable action taken by the police. In fact, they'd be unreasonable if they just let these people drive away. That's the state's position.
All right, and you're
I
at
see
your
my
time if
time's
you
up.
want to reserve 5.
Thank you.
Thank you. Mr. Thompson?
Please the court, counsel. For lack of a better word, the state's argument in this case is a series of red herrings. The shooting, it's a red herring. It has nothing to do with this case. It's earlier in the day, and there's just zero indication that that has anything to do with these two people in this car in the back of this parking lot. It's not a Terry stop. It's an arrest. That's what the trial court found, and that's what it was. So there has to be probable cause here. The police drive into this parking lot. They shine a spotlight into this car, and the two occupants start to pull out. We don't know what's in their mind. If it's, hey, something's going down, I don't want to be here either. The police, they comply with the police. What is the reasoning given for the stop? Failure to comply or obstructing official business. It's not a traffic stop. Even though they're in cars, it's not for a traffic violation. It was done at gunpoint with a big show of force. And I don't think that there's any argument that the trial court's finding that this was really an arrest and there wasn't probable cause.
Was there some I seem to recall something, and maybe I'm misremembering it, that the car was illegally parked? Because when I watched the video, like, it seems to be parked properly in a space, and I wasn't sure, like, where that came out in the testimony.
I recall that phrase, I do.
Mm-hmm.
And I remember that appellate counsel on my side raised that. But I don't know how you could illegally park or improperly park in a private parking lot.
Right. Okay.
So I can't explicitly answer your question, but
Sure.
I do think that that is also a red herring ultimately.
Let me ask you this, Mr. Thompson. I know our duty as an appellate court is to review, we're bound to accept the court's findings of fact. If they're supported by competent, credible evidence, the appellate court must then independently decide as a matter of law whether the trial court's conclusions satisfy the legal standard. We've all read the judge's decision. This is a transcript. Those yellow tabs are points of interest, at least I had while I was reading the transcript. So what are we to do if in our opinion, the trial court ignores unrebutted facts and limits their decision to certain facts that they decide are relevant? Are we allowed to look at these other facts and determine whether it was a valid Terry stop or whether it was inevitable discovery? How would you answer that?
This court gives deference to the findings of fact.
Right, but what I'm saying is, what if there,
Right.
there's three specific facts this court found. I have a list of 15 or so that I would have found of interest. So we're allowed to consider those facts.
You can consider any facts that are in the record. The question is applying those facts to the law. And
Well, I guess, tying off of Judge Winkler's point, as I read the trial court's decision, it's predominantly focused on probable cause or the lack thereof, which, as I read the state's opposition below, is all about probable cause. It's not about reasonable suspicion. So was reasonable suspicion litigated below, or was this all about probable cause?
this was all about probable cause. This wasn't about a Terry stop or a traffic stop or anything of that nature. It was about an obstruction, a fleeing and eluding, I think.
And counsel, what do we do with that? So below, the state advanced this argument that there was probable cause for an obstruction of official business charge, and that's why the stop was justified. And the trial court really confined its analysis to that argument. In fact, there's that footnote where the trial court says, I'm just looking at what the state is arguing. I'm not going to, come up with other reasons why this might be justified. And now we're presented with a different argument by the state, which is that there's reasonable suspicion, and then officer safety justified these additional intrusions. what are we reviewing? Are we reviewing the OOB and probable cause argument, or are we reviewing reasonable suspicion? Can the state change its theory? Is it bound by the theory it advanced below?
It is bound by the theory it advanced below, and to argue anything else, those arguments are waived or forfeited. The facts, sure, are sometimes open to debate, but the arguments that presented aren't. And the question below was probable cause.
Well, below, and Judge Winkler brought this up, below the state advanced, in addition to probable cause, an inevitable discovery argument. Can you address that?
Ultimately, the search itself was not argued by the defense below. It was explicitly waived.
By the defense or by the prosecution?
The defense. They didn't challenge the search. It's all about the stop. And
Oh,
the,
okay.
So there can be no inevitable discovery if the stop itself was bad, is our position here. I'd also just say that discouraging police activity is a red herring as well. Nobody is discouraging the police to investigate things. We just simply review whether they were done in line with the Constitution. If they didn't, it's okay. We just don't use this evidence. But the police, they go and they investigate, and that's the way that it works. So I just argue that that is a red herring as well. If there are no further questions, I will ask the court to affirm the trial court's decision.
Great, thank you. Mr. Cummins, you have 5 minutes.
Yes, Your Honors, I think, unfortunately, the court and the parties, they went down a rabbit hole about this obstruction of official business. But really, at this point, it's this court's job at this juncture just to look at the record, look at the facts, and look at the law and see if an
But
appropriate.
that was a rabbit hole that the state encouraged it to go down.
Yeah, I think the prosecutor mentioned it, and then the defense counsel mentioned it, and the trial
That
court
was the
really
basis
jumped
for,
on it.
that's what the officer said was the initial basis for the stop.
I think you might be right. I think that prosecutor was the first one to say that. You're right. But that doesn't really affect the reasonableness of what happened, and it doesn't really affect this court's analysis in the end. This court is only bound by what happened below if the trial court's findings were supported by competent evidence. The trial court made a lot of errors. The trial
Well,
court.
counsel, then in that regard, and just getting back to my question of what are we reviewing, the state is asking us to take a look at what the trial court did implicitly by filing this appeal. So don't we have to look at the probable cause and OOB findings in order to look at whether what the trial court did was correct?
If you want to put it that way, I'll reduce it even farther. I would say basically, the trial court granted the motion to suppress, and I think that the state is asking this court to review the record and determine, hey, was what happened here constitutionally reasonable? Because that really is the Fourth Amendment analysis. Was it reasonable here under these circumstances for the officers to want to ask these guys some questions and to detain them to do so briefly and do it in whatever manner they had
But
to
getting
do.
back to like what I was asking Mr. Thompson, like if your main argument below is probable cause and now your argument is reasonable suspicion, like did you make the reasonable suspicion argument below? Because it's not in your memo and op at all. So like, did you advance that argument below? Because if you're criticizing the trial court's findings and saying, well, she didn't make certain findings, then it had to be incumbent upon the state to raise those arguments so that she made appropriate findings.
Well, first of all, that citation to the McClarty case talks about defendants having to raise issues, and if they don't raise them, they're waived. I don't think it necessarily means that the state is tied to some argument the prosecutor made. The state's burden ultimately at this motion hearing is to defend the reasonableness of the incursion of the defendant's rights. Was it reasonable given what was elicited? And I think clearly it was. I think the officers themselves testified that they had reasonable suspicion in their minds as soon as they identified that car, the specific car they were sent to look for. They testified that they felt they had all they needed to talk to these guys. That's all they thought they needed. They went on to say that after we identified that car, we saw movements and we put a light on it, and as soon as they realized it was a police, they started to leave. That just provided more circumstances to raise the reasonable suspicion. But it's the state's contention that.
Well, again,
reasonable suspicion
getting back to my question, did the prosecutor below specifically argue reasonable suspicion and ask the court to make a finding on reasonable suspicion here?
I don't remember if he actually used reasonable suspicion. He may not have, but I don't think that's determinative of this court's role. I think this court's function is to review the record and determine.
Well, but I mean, it's appellate advocacy 101 that we can only review arguments that were raised below. Like, that works for the defense, it works for the state. Like, if you don't make arguments, like, we can't review it.
Well, I think implicit in the whole state's argument below was what happened was proper. It was reasonable. It was constitutional. That's what underlies the state's position. Whether or not they pointed to obstruction of official business or fleeing and eluding, those truly are red herrings. That's not as important as to determining whether or not the officers' actions that they took wasn't reasonable. It's certain. I'm sure that the community expected them to investigate. I think the officers thought that it was incumbent upon them to do so. As soon as they get a dispatch for a specific car and they find that car, I think they'd be derelict and just letting them drive away. I think everything that went down here was reasonable, and I think all the parties here are going down rabbit holes and getting confused by issues and statutes that really is not relevant to the ultimate inquiry, which is whether or not what happened here was reasonable given the totality of circumstances. And as the Supreme Court of Ohio said, we must not fall into this trap of looking at things in isolation and getting waylaid by saying that the shooting is irrelevant to this. That's outrageous. The shooting sets the whole background of this day for the officers and for the residents of that community and for all the people phoning into the police department. It's central to it. To dismiss that as irrelevant is putting blinders on, and that approach has been rejected by the Ohio Supreme Court. You have to look at everything that happened that day, everything the officers knew. And clearly their actions.
And you're at your time now.
Okay.
Great.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision, and hope you both have a great day.